Good afternoon, ladies and gentlemen. Welcome to Burn the Corporate Fiction, or morning, depending on where you're tuning in from. Today, I'm going to go over what we discuss in the Jurist Society. For those of you who do not know what the Jurist Society is the membership program to this channel, or the membership group, rather, to this channel. You can join on either YouTube or Facebook. I just opened up the memberships on Facebook, so if you guys are interested, we're a close-knit, tight-knit community of jurists who study law, remedies, and we have a bunch of templates from everything that we have done and are doing, plenty of treatises on law. And essentially, I'm going to explain to you our process, why we do it and why it works. So in order to do that, we have to start by examining what law is, right? So when we became independent here in the United States, and actually what I'm going to teach is applicable in both Canada, the United Kingdom, and anywhere that has recently been a common law nation now. You know, like China, I'm pretty sure they've been imperial for a long, long time. But the point is common law is the fundamental and original jurisdiction of all nations. The very first compact or agreement or trust that's entered into by the people of a nation must take place at common law, because common law is not written by man. It's written about by men. It's observed, discovered, applied to society. It's the law of nature, nature's God, the Mosaic precepts and divine revelation, and the customs and practices of the people that arise from the former two. So we have to take a look at what law is. Then we're going to look at how they subverted it with the 14th Amendment. And then there's going to be an added aspect to this, because claiming your estate and expatriating from the 14th Amendment citizenship are essential, and they give you standing to fight, but that's not the end. That's not the final thing. Is a private express trust. And we're going to take a look at what a private express trust is, why it works, how it creates a natural person under the law of the land, and it is above the statutes, codes, and regulations of the municipalities, the counties, all the various administrative agencies, because Article 1, Section 10 prevents any state from passing any law ex post facto impairing the performance of the obligations of contracts. And the Supreme Court has upheld this many times. This is actually what the Carnegies, the Rockefellers, and even the Rothschilds have historically used to protect their assets and keep it in the private. As a 14th Amendment citizen, nothing you have is private. Literally, 14th Amendment citizenship is a public trust office. That's the problem with it. You are you're federal personnel, you're federal enfranchisement with deferred retirement benefits, and everything that you have has been pledged as collateral for the public debt. And we're going to go over that as well. But let me say hi to those of you in the chat. We have Nate X. Good to see you, man. We got Pat, as always. Good to see you, Scott. We have Josh. Say what? Good to see you, fellow jurist. We got Roger Ledwell this morning. Excellent. Good to see you. Brian Roy, and one more quarter on both Rumble and YouTube. Right on. All right, so I'm going to get into this. We have to start with a very, very important case that everyone should have a copy of. You can either print it off Justia or go to Harvard Case Law Access Project. It's Chisholm v. Georgia, 2 U.S., which is the volume 2, U.S. 419 from 1793. What I generally do when I'm researching cases, I go to, you always want that volume number, which is 2 U.S., this one right here, okay? And then you just go to volume 2 of the U.S. Courts and Harvard Case Law Access Project. And instead of scrolling through all the cases to look for Chisholm, just hit Control F and type in Chisholm, and it'll pull it right up. Just a little cheat code for legal research for those of you that are law dogs. So it says right here, and as I was saying, when we became independent, we didn't create a new law. We didn't become independent and go, hey, what type of law do you think we should have? No, we continued using the common law, which is the original jurisdiction, the one not written by man, except for the major change was we were no longer subjects of the crown, nor were we under the church, right? We were truly sovereign. And this case actually encapsulates that. It records it for perpetual record right here. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of this country, but they are sovereigns without subjects. and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Now, what we're going to be looking at today is in many of these cases, in many of our original law books, there was a very anti-feudal sentiment permeated all throughout the United States. And the reason being is because what we started this country to get away from, what we won our independence for, was to get away from feudal tenures. Feudalism, see, prior to William the Conqueror, I explain this all the time, I'm not going to go into it too much, but prior to William the Conqueror, the English held their titles allodial. For those of you who do not know what allodial title is, it means free of any superior claim, absolute ownership. You are the sovereign of that land. See, the people in this republic are sovereign because they have a allodial title, and they have a allodial title because they are sovereign. This is really important to understand. The only way man can enforce his will against another man or woman, right, is if that other man or woman is using property that belongs to them. So they're not necessarily enforcing their will against you. They're forcing their will against their property, which you're using, and all rights are derived from property. Your relationship to your property is called your status, your status. That's the Latin word for estate. And your relationship to your property determines the law you're under. And as you see here, we were sovereign. And I'll further prove this, that we were sovereign. This is Wisconsin Constitution of 1848. And Article 1, Section 14 says, all lands within this state are declared to be allodial, and feudal tenures are prohibited. See, again, that feudalism sentiment permeated throughout this constitution, because that is, feudalism is essentially communism or fascism, depending on how you want to look at it, two different expressions of feudalism. But feudalism is essentially state control of all labor and property. You know, so the state, where the crown takes control of all the land and thereby can determine how the people behave on that land and what they do with that land, because they're not controlling the free will of the people, they're controlling the use of their land. It's quite crafty. Okay, so actually, I'll even prove this to you further. We go to Black's Law Dictionary, or I'm sorry, not Black's Law Dictionary. What am I thinking? Blackstone's Commentaries. We're going to shoot down to page 330 real quick, because I was going to show you something else from out of there. But this is a very good book. You can get it for free right off archive.org. You should have both volumes. So there's 331. Okay, 330. Look at this. For whereas before the possessions of their subjects were perfectly allodial, that is, wholly independent and held of no superior at all, now they parceled out their royal territories, or persuaded their subjects to surrender up and retake their own landed property, which is exactly what you do when you register anything, your child, your car, land. It doesn't matter. When you register it, you're surrendering it up. Okay. And then what the state does, and what William the Conqueror did here, where it says retake their own landed property, they gift it back to you in feudum. Okay, so it says under like feudal obligations. And thus, in the compass of a very few years, the feudal constitution and the doctrine of tenure extended itself over all the Western world, right? So, and this document right here, which I should have had it open to the page, but no big deal. There's a ton of case law in this, right? So we're going to go to, I believe it's section 12. And this is a treatise on the American law of administration. And we want, bear with me for a second. Yep, book first. The scope, testamentary. No, we want to go up here. The feudal, here we go. So he tells you that when this happened, so it says in England, after the conquest, which put an end to all absolute ownership in land, and thus did violence to the principle upon which property rests. Now, these two treaties separate each other by over 100 years. Okay, the former was, I want to say, 1760s, Blackstone's Commentaries, and this one was the late 1800s, but they all jurists recognized this. What William the Conqueror did, and coincidentally what who all politicians and royals trace their lineage back to, is this Norman bastard called King William the Conqueror. Because of this, what he did was he essentially created the beginnings of what is now becoming a technocratic feudal, neo-feudal state, right? And the way that he did this was he caused these barons to voluntarily, or these nobles to voluntarily give up their land, register, just like you voluntarily go register your car, right? And then what happens? The state issues commercial advertising called a license plate. You put it on the back of your car, and road pirates can create an attachment to your trust in order to generate their own commercial paper. But I'm getting ahead of myself, right? So we see that. So essentially, with the new republic being free and independent, and the people being enshrined as sovereignty, as we just seen in Chisholm v. Georgia, what that essentially meant was this was our law. I'll show you here. We go to page 47. Could have opened up several of these books and just had the pages ready, but whatever. It's kind of a lot for my web browser. All right, so 47, we're still not. So page 47. Dang, we went way down there, didn't we? 59. That's actually going to be important when it comes to equity. And I'm going to teach you about equity again, because there's a lot of confusion surrounding equity. And some people think that equity is good. It is not good. Okay. It allows the judge to be a tyrant. That's actually exactly what Bouvier says under discretion in Bouvier's Law Dictionary. He says he's supposed to decide according to equitable principles, but it's the law of tyrants, and it's different in different men. It's subject to all the vice and capriciousness of mankind, and it's not a good jurisdiction to be in. But here we go. He says the law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe, which, whatever, in all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately or immediately from the original. So that's why William the Conqueror had to do it this way, and that's why these banker oligarchs and the corporate oligarchs had to do it the same way. They had to get you to voluntarily surrender up your property in exchange for some sort of benefit like protection, welfare, et cetera, et cetera. And that's the only way they can do it, because then they can still trace it immediately back to the original law and say, well, they did decide to enter a state of dependence upon, on us. And so therefore they have to conform to our will, and we're allowed to regulate the property that they use because it's technically our property, or it's under our administration. Right. So he goes on to say, upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human law should be suffered to contradict these. And contrary to what you might believe, until you object to the presumption of infancy and incompetency, until you actually establish yourself on the record, which is what I'm going to show you guys today, they are not contradicting the law of nature, because as he says here, let's see, I think it is page 45. Man, considered as a creature, must necessarily be subject to the laws of his creator. Why? Because you cannot live without God. So therefore you have to be, and I know I describe this all the time, but it's such an important aspect of what's going on, right? You cannot exist without God. So common law being observed, not written by men, but observed, discovered, and applied to society by men, right? They go, okay, well, if we're all dependent on God and must subject ourselves to his will because we're dependent upon him, then anyone who becomes dependent on me, like these poor people or these incompetent lunatics, whatever, they have to subject themselves to my will. And that's what I mean by the application of natural law and divine revelation in society, right? So he goes on to say, a being independent of any other, meaning any other than the creator, because nobody's independent of the creator, has no rule to pursue but such as he prescribes himself to himself. But a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. So when you're a creature of the corporate state and you're on the government dole, or you're even looking to collect Social Security in the future, this is a benefit. They're saying you're incompetent. You cannot actually subsist off your own estate or save up for retirement, or, start a business, or you're going to need us when you're old, because without us, when you're old, there'll be nobody to take care of you. So you spend your entire life in a state of dependence because of that stupid Social Security number. That's a fact. So Nadek says, Ryan, I'm indebted to you. Well, that's heavy. As you made it possible for me to avoid certain unpleasantness back in 2024. infinite love, dude. That I appreciate that, man. I'm glad I could help you out. All right, so let's go back here. So now we understand what the law is absent of any kind of government institutions. When you're sovereign, right? When you're above the government, as we are in Chisholm v. Georgia, that's where we were. Where the hell did that case go? Oh, well, I'll pull it back up. There we go. Switch to that tab. Okay, so right here. So this is where we're at. At the Revolution, the sovereignty devolved on the people. We didn't create a new law. We just continued using the only actual law there is, common law. And now we were not subjects to the crown or under any kind of feudal tenures. And all lands in this nation were allodial, meaning when you were on your land, if a sheriff came on your land, unwarranted, right, in violation of your no trespassing signs, right, no trespass signs, right, then you could deal with him however you please if he does not get off your land, and there's nothing anybody could do about it. And this has actually happened in the history of this country before, and there was nothing anybody could do about it. You guys might be old enough to remember hearing stories about old farmers back in the early 1900s, late 1800s. They'd have no trespassing sign on their property, and they could fire at you. That's a fact. And then there's nothing anybody could do about it. That's what comes with being the king of your land. So we have it recorded in the Wisconsin Constitution. Oops, that's Weiss Concise Trustee Handbook. My bad. We have it recorded in the Wisconsin Constitution. And then I did come across something that you guys will probably find interesting. And it is, I got to pull it up real quick. Hold on one second. We are going to go allodial. Nope, that's not it. Downloads. Here it is. Or sorry, I saved it under land patents. That's why I couldn't find it. Here we go. So we're going to go down. This is right here. You guys will see that this is the annual report of the Commissioner of the General Land Office made to the Secretary of the Interior in the year 1870, just after the 14th Amendment. Okay. And we're going to go down to page 29. Right, so let me go ahead and now that I showed you what book it is, and you guys can find this is available online as well. Archive.org has it for now. Yeah, I would hurry up and get it after this stream because they tend to not like when this stuff is exposed. But look, American land titles on page 28, allodial tenures. In the celebrated ordinance of 1787, the Old Continental Congress for the government of the territory of the United States northwest of the Ohio River, which is the first legislation of Congress on the subject of landed property, the leading incidents of feudalism were specially repealed. The second section is an epitome of progressive and revolutionary legislation, embracing many of the points on which the issues between social progress and reactionary conservatism have turned. Okay, so it tells you right here, it says, it ordained and enacted that the estates of both resident and non-resident proprietors in said territory, which resident is a foreigner, dying intestate, shall descend to and be distributed among their children. This is cutting out the probate and ecclesiastical courts. It tells you down here on page 29, it says, it is purely allodial, right? So it says the individual title, up here on page 28, the individual title, no, I don't want you, Copilot. Anyways, the individual title derived from the government involves the entire transfer of ownership of the soil. It is purely allodial, with all the incidents pertaining to that as substantial as in the infancy of the Teutonic civilization, which actually the term allodial came from the Teutons, from the Germans, right? Or from the Nords, the Vikings, essentially. The Viking cultures, when they came to Britain in about 800 AD, they brought with them the concepts of government of the people and the concept of allodial title, which comes from the Old Norse Othala, which means ancestral inheritance. Okay, and it's also the origin of the word oath. Allodial essentially means all oath, right? And what it is because, like it says in Leviticus, the land shall not be sold forever. It's technically between you and God, it's a grant of dominion, which no other man has the right to intercede. That's why it's considered absolute ownership. But really, it's not ownership, it's absolute dominion, because nobody can actually own land. And the ancients understood this very well. And instead, what you did was you made a pact with God, right? Or in the Norse case, they're gods. But when it came to Britain, Christianized Britain, it's God. And you're swearing to be a good caretaker and steward of the land with which you've been granted dominion over. And so long as, you don't encumber it or sell it, nobody else can tell you how to use it. Nobody can come on it. Nothing can charge you a fee for it. So why do you pay property taxes, right? On your house. You think you own your house, but you pay property taxes. We'll get to that, right? I can actually show you. So it says, following in the wake of this fundamental reform in our state land laws, there are several others which constitute appropriate corollaries. The statute of uses was never adopted in the public land states, and hence the complex distinction between uses and trust has never embarrassed our jurisprudence. So wholly against feudalism, and we had absolute title. We had allodial title, and that's a fact. And now you see it in the general land office records, right? And you've seen it in Wisconsin state constitution. So make no mistake, we had absolute ownership. And when you have absolute ownership, you truly are sovereign. And that's the only time you have access to lawful rights. So now, before we move on to what we do in the Juris Society and stuff, we have to cover one more important aspect. And I'm going to try to summarize it real quickly because I talk about it quite often. So just watch any of my streams. If you're unfamiliar with the difference between law and equity. Okay, the first time I came upon this difference was when I was reading the Constitution. Article 3, Section 2 of the U.S. Constitution says the judicial power shall extend to all cases in law and equity arising under this Constitution. I noticed there was a distinction between law and equity. I'm like, okay, well, if equity, we've been hearing the word equity a lot, right? And this is years ago now, but we've been hearing the word equity a lot, and people have no idea what it means. Well, equity generally deals with fictions. Okay, that's why it was created, because the law cannot recognize fictions. And it came into common use and actually almost overtook law in its entirety back when it was named Chancery. And it rose in prominence because of the introduction of trusts into the Western world, right? And the whole feudal system that William the Conqueror created. That's why equity came into use. In fact, I'm going to pull up this other treatise I had forgot to show you. And this actually goes into trusts quite well. It's called a practical treatise on the law of trusts. And hold on, treatise on the law of. So it's got to be in my downloads. Bear with me one second. This is an afterthought. That's why I didn't have it prepared. A practical treatise. And this really reveals exactly what trusts are, right? Practical treatise on the law. Where the hell is my book at? Of trusts. An elementary treaty. Huh. Well, this is stupid. How come I can't find it? Let's just do law of trusts. This is an old book from the 1800s. Law of trusts. Right? No? All right, well, you know what? We'll do this. Let's go a practical treatise on the law of trust, and I'll just pull it up on archive, and I'll link it for everybody so you guys can have it as well. On the law of trusts. And it should pop up right here. And now I'll link it for all of you. Copy. And now you can have this document as well, or this treatise. It's very good. There, it's in the chat. What's up, Ryan? Good to see you, man. So we're going to go As the estate of the trust depends. I don't even think this is the right one. Well, no, it's not. Anyways, the guy says, and I'll find it and I'll show you guys later because I don't want to spend too much time on it. But what he says is that the parents of a trust were fraud and fear. He basically says the rise of trust is owed to the ingenuity of fraud. He says it was made so certain, tenants could basically circumvent the fruits of their labor and not have to give it to their lords, so that the church could hold lands against the statute of mortmain and all of that stuff. And he says that the parents of the trust were fear and fraud, and the court of conscience was its nurse. And so the court of conscience I bring up because that's the court of equity. Okay, so we'll look at what Blackstone says about equity. And the reason that trust can only be adjudicated in equity is because they're fictions. They're fake. The law cannot recognize that which does not exist in fact. The law can only deal with what is and what has happened, what exists in fact. It cannot deal with fantasy, basically. Oh, thank you. Thank you, Pat, says the, here we go. Yeah, I don't know why I shared that. A little technical difficulty. Window. I need to share the window. So there, it says the judicial power shall extend to all cases in law and equity arising under this Constitution. So equity actually supplements law in dealing with legal fictions, okay? But here are the stark warnings that people such as Blackstone had given about equity. We'll go down to page 59. If you guys are ever curious, you can just go back and look. I'll tell you what page numbers the important stuff that we're discussing are on. And so page 59, he says, equity thus depending essentially upon particular circumstances of each individual case, there can be no established rules and fixed precepts of equity laid down without destroying its very essence and reducing it to positive law. And he says, on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest we thereby destroy all law and leave the decision of every question entirely in the breast of a judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator and introduce the most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. Well, now you can see why the Bar Association would love to have equity and only equity, because it makes the judge a legislator. It makes him king. He's holding the king's conscience. That's what chancery / equity is, right? Well, they've successfully done that already. As many of you know, it tells you right here, in 1966, the Federal Rules of Civil Procedure were amended to effect the unification of civil and admiralty procedure. By the way, this is Equity and Admiralty, A Turbulent Path to Manifest Destiny. And it's from the Northwest Journal of International Law and Business. These law reviews are admissible as evidence in court, by the way. So that's how serious they are. So they unified civil and admiralty procedure, and it says, just as the 1938 rules abolished the distinction between actions at law and suits in equity. So they cannot get rid of law. And you might be going, well, how'd they do that then? How'd they bury law? Well, they locked you into a trust indenture, and trust can only be adjudicated in equity. And so after the bankruptcy and the Emergency Banking Relief Act, and after the Social Security Act, right, they were finally able in 1938 to say, well, everything is now just a matter of trust. That's what it is. They only hold their property in trust. It's been mortgaged. Everything's just a matter of trust. So now we can move entirely into equity, where the judge can play God, which he loves to do. And that's why, and we've seen Blackstone just warned us against this, right? It says, make every judge a legislator. Well, check this out. We go to federal, and you guys probably didn't see the Lodium stuff, did you? Because I had the stupid thing on the screen. Just show you this real quick. This is the land office, general land office, and it tells you that all of our lands are purely allodial, and essentially that we are seeking to avoid feudalism. Feudal tenures are prohibited by the Wisconsin Constitution right here. All lands within the state are declared to be allodial, and feudal tenures are prohibited, right? And so now let's take a look at Bouvier's Law Dictionary, okay? Oops. Under the letter D, we'll go down to discretion. Okay, this law dictionary was specifically adapted to the laws of the United States and the Constitution of the United States, right? The laws of the states and the Constitution of the United States, which means common law. This is primarily a common law dictionary with references to civil, Roman civil, and other forms of foreign law, but it's common law. So when we go down to discretion, which should be right about here, discount, there we go, discretion in practice, which means in courts, right? Says when it is said that something is left to the discretion of a judge, it signifies that he ought to decide according to rules of equity and the nature of circumstances. Okay. Then it goes on to say the discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. It is casual and depends upon constitution, temper, and passion. In the best, it is oftentimes caprice. In the worst, it is in every vice, folly, and passion to which human nature is liable. That's equity for you. That's what equity is, and that's why the judge wanted equity, courts of equity, pure equity. That's why. Okay. Good to see you, Kevin. I'm glad you made it. So you can only have a bench trial in equity because common law requires the right to a trial by jury, right? You can only have a bench trial where the judge goes, yeah, I heard what you said, but since I'm paid by the state and we have to maintain a 99% conviction rate because of the securities that we generate and immediately sell to institutional investors, we can't be left holding the bag. So no matter what you say, I'm going to find you guilty because I'm a scumbag pirate. That's what they do, right? So everything's equity, and it's the law of tyrants. Now that we've established that, right, let's take a look at what happened. So after the Civil War, obviously most of you know, Congress adjourned sine die without a day, right? Never actually lawfully reconvened, but that's not all. They ratified the Reconstruction Acts after they assassinated Abraham Lincoln, which that's the whole thing. And Andrew Johnson vetoed the 14th Amendment. Not only did he veto the 14th Amendment, but he vetoed the Civil Rights Act. But the whole thing was the federal corporation had been granted the power of controlling currency, right? Minting currency. And the plan had been the entire time to establish a central bank. But the problem for the federal corporation was it had no collateral of its own. It had no right to confer citizenship, okay? And it had no citizens of its own. And so what it needed to do, because it needed capital stock as collateral, it needed a pool of collateral and citizenry to be able to establish a central bank and then borrow against them to indenture them, which is what's happened. They decided to create their own federal class of citizen. And they did this first with the Civil Rights Act in 1866. And Andrew Johnson vetoed it. And he said, this is unnecessary. He says it was already presumed that one who was a citizen of a state was a citizen of the United States, but apparently this legislation proceeds to the contrary and purports to create its own class of federal citizen, right? And it's in violation of the rights of the states to confer citizenship. And so he vetoed it. And so it ended up being enacted anyways. And they're like, well, some future Congress can go ahead and repeal this. So we need to make it permanent. It needs to become an amendment to the Constitution. And that's where things got really sketchy. So the 14th Amendment was put up for ratification. And we're going to take a look at this. Was put up for ratification. And 15, this is House Congressional Record, June 13th, 1967. It begins on page 15641. And it says, and this is right off the government printing office, right off congress.gov. That's where I get all my stuff almost all my stuff. It says the 14th Amendment, equal protection law or tool of usurpation. And it goes on to tell you that pretermitting the ineffectiveness of said resolution as above, 15 states out of the then 37 states of the Union rejected the proposed 14th Amendment between the date of its submission and the states by the Secretary of State on June 16th, 1866 and March 24th, 1868, right? Thereby nullifying the resolution and making it impossible for its ratification. Now, for those of you who don't know, the 14th Amendment is what creates the U.S. citizen. Bouvier's Law Dictionary, not Bouvier's, Black's Law Dictionary, and we're going to go to Black's Law 4th edition, which I know I have right here. Hold on. Black's Law. Oh, we'll do 4th edition. We'll open this up. Okay. So we're going to go to 14th Amendment. It's way up here. I was actually looking at operator. By the way, driver is absolutely a commercial term. It's one employed, and that's important. I'll cover that shortly. But all right, so let's go down to 14th Amendment. Geez, there's a lot of D words, apparently. All right, we need to go a little faster. E, F, F-I, F-O. Okay. Should be right about, nope, forum. Here it is. Okay, so let's zoom in for you guys so you can read it. 14th Amendment. It became part of the organic law July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizenship of the United States as distinct from that of the states. And because it is a creature of the federal corporation, and it's offering privileges, immunities, benefits, and protection, it is a trust office, is a public trust office. And being a creature of the federal corporation, it is entirely subject to the legislation of that corporation. I'll show you. Maxwell v. Dow tells you, and this is a case from 1900. Okay, so there's the citation. Where are we at here? Well, you see the citation. I'm not going to read it off. Anyway, the privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. What? So the United States citizen does not have the guaranteed protection of the Bill of Rights? How is that possible? Well, it's very possible once you realize what the 14th Amendment citizen is a federal enfranchisement. The people created the states and stand above them. Right here, we see that. At the Revolution, sovereignty devolved on the people, right? The states got together and created the feudal or federal government, right? And stand above it. So the federal corporation got smart and was like, well, we're going to create our own creature called the 14th Amendment. And you'll see how important it was to them to get ratified. So we have this. It required 3/4 majority to be ratified, first of all. And it was rejected by 15 out of the then 37 states. Okay, so it did not receive the 3/4 majority. Here's a list of the states that rejected it: Texas, Georgia, Florida, Alabama, North Carolina, Arkansas, South Carolina, Kentucky, Virginia, Louisiana, Delaware, Maryland, Mississippi, Ohio, and New Jersey. So even northern states, because what they would want you to believe, what the false historians, what they would try to tell you is, oh, well, they didn't want the newly freed slaves having any civil rights. No, that's not why they rejected it. Andrew Johnson's veto message makes it clear. It's because it was the usurpation of state citizenry and state rights. Okay, and it was bringing everyone under a corporate union as federal enfranchisements. And then, obviously, with the intent to establish a central bank, that was so they could mortgage your property rights as surety to issue debt currency. And then they could create a series of national trusts around the world and eventually unify them into a one world trust or New World Order. And we're on the cusp of that right now. So we go down here and we see that it says, this is why it's unconstitutional. So when you're expatriating, there's 2 things that you need to put. First of all, I guess I could cover this first, that it is voluntary. Okay, this is McDonald v. State 90, volume 90 of the Indiana Supreme Court, 320, right? And it's McDonald with 1 N, McDonel, versus State. You need to look it up and you need to have this because it tells you right here the evidence of bushing on his voir dire, which was the competency test for a juror, examination for a juror, showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. This is so very important. Okay, so the story behind this guy got found guilty of a crime by a jury, right? And he tried to challenge it because one of the jurors had just moved from Germany to Indiana, but he had naturalized within the state, but he was not a United States citizen. So the convicted tried to say, well, he's an alien. He's not even a United States citizen. And they said, wrong. He's a state citizen, and that's all that matters. Okay, you do not have to be a United States citizen ever. So not only is it voluntary when you're expatriating, okay, but it was never lawfully ratified. And everything they do hinges on this amendment, okay? It hinges on this citizenship. So we have this right here. It says the Constitution strikes the 14th Amendment with nullity. The defenders of the 14th Amendment, right, contend that the U.S. Supreme Court has finally decided upon its validity. Such is not the case. And you'll actually have lawyers try to tell you that. And even judges, oh, well, the Supreme Court's already validated the 14th Amendment. No, they have not, ever. They will not even look at the question of its validity, because if they do, they have to strike it with nullity. And that's what they're supposed to be there for. That's what the Supreme Court's supposed to be there for. I mean, the federal judiciary, Thomas Jefferson warned when the Constitution was unlawfully ratified against the will of the people in place of the Articles of Confederation, which were impenetrable, right? Impenetrable were the Articles of Confederation. We'll go through that here shortly as well. They replaced it with the Constitution, which created a federal judiciary. And Thomas Jefferson said the seed of dissolution, or the germ of dissolution, is seated within the federal judiciary, which shall work like gravity by night and by day to usurp the sovereignty of the states. And they immediately did. The Supreme Court, right, the main object of the Constitution, to give the Bar Association a backdoor into our system of jurisprudence. And of course, Article 1, Section 8, the Commerce Clause, is a huge part of it as well, of why they why they ratified the Constitution against the will of the people, right? But that's why they exist. And they're supposed to take a look at this, and they never have. And it's actually enshrined in Coleman v. Miller, right? Which I've pulled up that case, read it, looked at it. We went through it in the Jury Society, and it is enshrined. The fact that the U.S. Supreme Court did not uphold the validity of the 14th Amendment. Now, they didn't declare it invalid either. They will not look at it, because if they look at it, they will declare it nullified and invalid. They have to. And this is why. Because he goes on to say, right, that says the fact that these three states, right, so it says, hold on, we'll go up a little bit. It says right here, it says the legislatures of Georgia, North Carolina, and South Carolina had rejected the amendment in November and December of 1866. New governments were erected in those states and in others under the direction of Congress. Okay, so Article 5 says no state shall be deprived of its equal suffrage in the amendment process of the Constitution. So these states that rejected the 14th Amendment, Congress sent the military down, and this is actually why Andrew Johnson was impeached, because he refused to send the military down there. He was the commander-in-chief of the military, and he said, no, I'm not sending the military. And so somehow Congress just took the authority upon itself to become commander-in-chief of the military and sent the frickin' military down into these states and removed their legislatures at gunpoint. Indirect contradiction of Article 5 of the Constitution. Therefore, and then the new governments that Congress installed in these states went ahead and ratified the 14th Amendment. Nope, that doesn't count. Never, not in any universe does that count, right? So he says over here, yes, it was insurrection. And good to see you, Sergeant Frog Dog, by the way. It says right here, the fifth article is a grant of authority by the people to Congress. The determination of the method of ratification is the exercise of a national power specifically granted by the Constitution. That power is conferred upon Congress and is limited to two methods: by action of the legislatures of 3/4 of the states, or conventions in a like number of states. So it has to be 3/4, right? It says the Constitution, or the framers of the Constitution, might have adopted a different method. Ratification might have been left to a vote of the people or to some authority of government other than that selected. The language of the article is plain and admits of no doubt in its interpretation. It is not the function of the courts or legislative bodies, national or state, to alter the method with which the Constitution has fixed, right? So We submit that none of these cases in which the court avoided the constitutional issues involved in the composition of Congress, which adopted the joint resolution for the 14th Amendment, did the court pass upon the constitutionality of the Congress which purported to adopt the joint resolution for the 14th Amendment. So this is still an open question. To this day, they have never looked at it. They will not look at it because they're a bunch of corrupt bar pirates. We, the people, could petition them to look at it, but we have to educate people and get them to understand, first of all, what United States citizenship is and why it's not only voluntary and why you should not adopt it. It's a bad deal. You don't even have the protection of the Bill of Rights. So you're granted privileges, immunities called civil rights. So, you can, I guess, being gay is unlawful at common law, but you can be, now you have gay rights somehow with the 14th Amendment, but whatever. And no offense to you if you are, that's your business. I'm just stating the facts here. And, so you get privileges, immunities, benefits like welfare, Social Security, all that good stuff, right? And protection. So the U.S. daddy government is going to spank anybody who tries to abridge your privileges and immunities, right? But in exchange, you are entirely subject to the legislation of Congress. And Congress gave you those privileges and immunities. They can take them away. And that's why you're not protected by the first 8 amendments of the Constitution. The privileges and immunities of the citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Why? Because you're not one of we the people. You're not one of we the people. So not only is it voluntary and you should not want to be a part of it, but you should also realize that it is entirely nullified and void. It was never constitutionally ratified. So this is why our claim on the estate works in the Jury Society. Jeff says it's his understanding Johnson was impeached for trying to replace his Secretary of War. Exactly, because they were sending the military down into the fucking states to remove their duly elected legislatures, which is insane. So that's why the lawful claim of title serves as an expatriation and a performance contract to give you the lawful standing as one of we the people to fight back. So let's go through the process here. The very first thing you have to do is establish a house and seal. Okay, so I'll give you an example of what that looks like. This is what our Juris Society folder looks like. And in here, you have templates. These are all the different templates. We got cover letter for abatement, which is to essentially void a case, right? We have a bunch of trust documents, right? A notice and understanding of intent, which is part of administrative process. We have declarations, how to write a declaration, right? Notice to file on demand, notice of liability. This one's actually pretty cool. For after you file your claim, you can send this to whoever it is. Make sure you sign and seal it, and let them know that, hey, you're entering a performance contract, right? But that's not why I bring this up. This is the very first step right here. It's called the Declaration, Establishment, and Publication of House Seal. Okay, and so down here is this figure 1. I don't know why when I upload it to Mega it messes up the document, but in the Word document, the figure 1's over here, and that's where your seal would be. And by establishing your seal, you establish your house on the record. And that's very important because, as we'll see here, where is the Illinois? Right here. Oops, damn it. I just apparently closed that for whatever reason. Did not mean to do that. All right, kind of right here. Let's reopen it. There we go. All right, so this is in the schedule. So a schedule is like, okay, this is our first. This is the Constitution of Illinois. We've just created this government for the state of Illinois. Now, how is it going to be put into action? How is it going to be executed? And that's put in the schedule. And you go down to section 6, and you'll notice that it says the governor of this state shall make use of his private seal until a state seal shall be provided. Why is that? Because at common law, people who have their stuff together have a house and a seal. And it was presumed that anyone who would be eligible to be governor of the state would also have established his house and seal. And so he was going to use his private seal until a public one can be made, right? And the house is your very first layer of political protection, and your seal is your protection against anyone entering you into contracts or agreements that you personally did not consent to. So when you establish your seal, you're also casting the shadow of doubt on all prior agreements that you're presumed to have been entered into. So, all right. So we go, yeah, actually, Faye. So Corbett says, I haven't verified it yet, but you might be able to create certified mail from it. No, Faye figured it out. She's been sending certified mail without paying for it, without having to pay for it or anything. So we should actually go through that video in the Juror Society meeting tonight. So, all right. Anyways, so you want to establish your house and seal. Then you claim your estate. And in this very, very long claim that took a very long time to type out, one of the most important parts is the conclusion, where you literally expatriate and you cite your reasons for expatriation. Okay. And so we have that the majority shall prevail is a rule posterior to the formation of government results from it. It's not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. That's important, because then what that means is what that whole case, Cruden v. Neal, is about is when the form of government is changed, it requires consent, and all brand new consent, right? From the people that are going to be under it, because now it's a new form of government. So when the former form of government is abolished and the new form of government takes place, so that case, particularly Cruden v. Neal, what it was about was a British loyalist was being brought up for being a traitor after the war, and the justice wisely determined that no, you cannot. There was no United States of America when he was just being loyal to the king. Right. And so we form this new institution of government here in society, and he has to consent to be a part of it. Right. So at the revolution, essentially all men entered, or after the revolution, all men re-entered a state of nature, and it required consent to the new forms of government. Right. Which is why it was set up so well under the Articles of Confederation. And, this guy didn't want to consent. So the reason that I put this here is because between the 30s and 70s, so the 30s and 40s, the federal corporation adopted your Uniform Commercial Code. Well, first, the Emergency Banking Relief Act, which mortgaged your estates, the Social Security Act, which created a trust to tie all your registrable property to, the Trust Indenture Act in 1939, then you have your UCC Acts, Investment Company Acts, Housing Acts, all that stuff, right? Administrative Procedures Act, one of the most important ones. And then between the 60s and 70s, all of the states adopted their own versions of those same enactments, right? And when that was finalized, our original de jure form of governments within the states had been abolished, altered or abolished. And so this very case right here, Cruden v. Neal, applies to us as well. We do not have to, no, this isn't our de jure form of government. And to be a part of this society that you've now created, this commercial, materialistic, fictional society, right? This society of corporate fictions requires our consent. So you expatriate from the record. Now, this is the final step here. And this is important because this gives you the standing to fight them. All right, this gives you the ability to say that my estate's not under administration. I'm not conveying the right of my property to the state to be used as collateral. In fact, we'll watch a video here in a few moments that you guys will appreciate. Mojo Shop actually sent it to me, and it was a very, very, very good video. And I think that you guys will all enjoy it because he says much of what I'm saying right now. So let me send it to myself real quick just to have it prepared. All right, so there it is. All right, so now all your registrable property, though, you're going to want to put in a private trust. So let's go here. This is an excellent book called Weiss Concise Trustee Handbook. You can get it on archive.org. I have it in the Juris Society folder. It's only about a 65-page document, but it's powerful. It's very good. And he goes through and explains how this is what the Rockefellers and the Carnegies did. This guy, if I remember correctly, was a lawyer who was hired to fight against people like me, like us, right? And after he retired from doing so, he wrote this book and said, if these people would have just done this one thing right here, create this private express trust or a series of private trusts, then there would have been nothing I could do. And so he goes through and explains exactly how this works, right? So he says, the court held, so this is in Barry v. McCourt, right? It says the court held that an express trust is a contractual relationship based on trust form. It was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is therefore violative of Article 1, Section 10 of the Constitution. Because the express trust is created by the exercise of the natural right to contract, which cannot be abridged, the agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws passed by any of the several state legislatures. Right? The court made it clear in Elliott v. Freeman that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court and that the trust relationship comes under the realm of equity based upon the common law right of contract. So it's not the Roman civil law commercial equity. It is the equity that is complementary to common law, and there is a difference. And it is not subject to the legislative restrictions as are corporations and other organizations created by legislative authority. So what happens here essentially is when you create a private express trust, it's a common law contract. You're not creating a trust by the authority of the state like corporations are, or the United States like corporations really are now as 14th Amendment citizens. And therefore, the trust is not a creature of the state, but it is a separate, distinct legal person. It's considered a natural person, all right? And it exists outside of the state under the law of the land. Now, trust can only be adjudicated in equity. This is where it gets confusing for some people who don't have a great grasp on the difference between law and equity. But as far as the trust is concerned, it has all the same common law rights to property as one of we the people originally did, as outlined in Chisholm v. Georgia, right prior to the 14th Amendment, because the 14th Amendment is its own trust office, and it's a separate, distinctly separate trust from the one you're creating, and even that of anything created by the authority of the state originally prior to the 14th Amendment. So so among these rights would be the right to hold land allodially, right? The right to hold property in general in allodium, because that is what one of we the people, one of our rights that we have under the common law. And that's what he's getting at. You're creating a private person, a private legal person, a natural person that exists outside of the authority of the state, the corporate state. And because it's created by the common law right to contract, right, under the common law of contracts, it's protected by Article 1, Section 10. These court cases uphold it. There's volumes of court cases that literally uphold the private express trust and the powers of the trust against the powers of the state. So this is where I get crafty with my trust. And I'm just going to show you guys a little bit of it. We were having a Juris Society meeting when we read this entire book. We read this entire book in the Juris Society and discussed it. And I explained, we explained things and stuff like that. And then I got this idea while I was reading. I was like, well, what if you create a trust that is specifically forbidden from engaging in any kind of public commercial activity, interstate or international or otherwise, right? But see, the trick with it is that a trust cannot be created with the intent to circumvent any kind of statute or code or anything like that. So that cannot be the intent of it. But if it happens to do that because of its terms, right? See, because the statute and code cannot impair your performance of the obligations of a contract. So if you're the trustee of the estate and say you place your automobile, you sell your automobile to your trust. Okay. The trust buys the automobile with lawful consideration, which would be gold or silver. You draw up a bill of sale. It goes into the records. Now, because this trust used gold to buy the automobile, it has lawful ownership rights because gold is the substance of the law of the land. That's why they took it away to put you in a trust office. See, if you cannot own anything, if you cannot buy anything, you cannot own anything. And when you have no access to lawful money, you have no lawful rights to anything. And that's another way that they've trapped you into equity, is by taking the lawful consideration, the constitutionally lawful consideration of this republic. So that's why everything the trust does, it has to remain outside of public interest, and it has to engage in trade with actual lawful money, right? So let me see if I can find this right here. Look, he writes, a generally unknown fact is that there are several types of citizens now existing in America. The trustees of an express trust may seek protection under the constitutions as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment, which we will discuss in a later section. However, which I've been discussing the whole time here with you guys. However, it should also be noted of all citizenship, the 14th Amendment or otherwise, that jurisdiction over natural and artificial persons is distinguished without fundamental difference. This stems surprisingly from the operation of in rem jurisdiction, which underlies all civil law. Yes, it does, against the thing, right? Though all courts are familiar with action in personam against persons, it is action in rem against things which, though practiced only in maritime law, stealthily operates in every civil and criminal court. This principle is one of the least understood in its entirety. In rem jurisdiction over a man or woman can only exist if the man or woman is a slave, i.e. property or res. That's why I tell you the 14th Amendment citizenship is a trust office. It makes you public chattel property. In which case, his or her disposition at law is no different than if he or she were a horse or other goods. See the Zong Gregson v. Gilbert, which is a horrific case. If you read that, it's an English case, English reports, right? 3233. And essentially they threw slaves overboard because they ran out of, food, and they were running out of supplies. So they're like, okay, well, we can't feed these people, and it's horrific. And they chucked them overboard. And then when the case came to court, it was like, well, they weren't throwing people overboard. They were throwing property overboard. That's literally how they looked at it. And that's how they look at you, as chattel property, right? Useless eaters. Isn't that what they like to call us? Human resources. So in nature, in rem jurisdiction is exercised over men and women by their creator exclusively. That's why I say so. Equity, the realm of equity, belongs to only God and Jesus Christ. It does not belong to the black robe priest of Satan sitting up there pretending to be God. It does not. Okay, so only God, only Jesus Christ has the wisdom necessary to be able to exercise the jurisdiction of equity. Okay, in nature, in rem jurisdiction over men and women is exercised by their creator exclusively. Okay. So governments can therefore gain only a fictional in rem jurisdiction over men by creating various legal devices, personas, right? For those men to assume limited control of, e.g. citizen, taxpayer, driver, right? Since the device is a legal fiction, a falsehood made true by force of law, this persona is in fact a legal object or res. Just as in theater, the persona, person, is separate from the man or woman playing the part. Therefore, there may be artificial persons, but not artificial men, natural persons, but not natural men. So, and this is interesting. People say, well, sovereign citizen is an oxymoron. Normally, yes. But see, in this country, there had never been a system created like this, where the people were enshrined as the sovereignty and as the grantors of the trust that is government. Government is always a trust. Okay, it's always a trust created by the common law of contracts via the Constitution. That Constitution's, it should be the Articles of Confederation, right? The Articles of Confederation were what originally created the trust, right? That was the union of these smaller trusts. And then your state constitution created that trust. And when you take on the trust office of state citizen, you're taking an office that is one of the grantors of the trust, right? One of the controllers of the trust as a state citizen. So you're above the government. But you didn't have to be a state citizen also to enjoy common law rights and protections. We'll look at the Articles of Confederation real quick, and we'll go to Article 4. the better to secure and perpetuate mutual friendship and intercourse among the people of different states in this union, the free inhabitants of each of these states, with paupers, vagabonds, and fugitives from justice excepted. Yes, it has always been unlawful to be a pauper, vagabond, fugitive. Obviously, you would be taken under administration because you were considered to not have free will or be able to exercise your free will wisely to take care of yourself. And that's just the operation of law. You may not like to hear that, but it's true. Says so all the free inhabitants of each of these states shall be entitled to all the privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade, commerce, subject to the same duties and positions. You didn't have to be a citizen to still enjoy your sovereignty, your freehold, and your allodial title. It wasn't required. If you wanted to participate in the government, then you had to adopt the trust office of state citizen. That's true, right? And then once you adopted the elected office, you became indentured. You became indentured, bound to a term of service for years, just like any other indenture. So it's important to understand. Okay. Carlton goes on to say, Carlton Weiss, he says, Gaius says, de juris divisione, the divisions of law immediately preceding the division of the law then follows. The condition or status of men. It says, in the Institutes, de jura personarum precedes the expression, all our civil law relates either to persons or to things or to actions. The words persona and personae did not have the meaning in the Roman which attaches to the homo, the individual, or a man in English. It had peculiar reference to artificial beings and the condition or status of individuals. Now, I'm not going to bore you guys, but he goes on to say that the word person actually comes from this old mask, the vox, it was called a vox personabat, and it was a mask that would literally amplify the actor's voice. So when you are a person, you're adopting a persona. You're adopting a character, a role, a legal fiction that can then be taken in rem or in quasi-rem is generally what they do against the thing. So let's break this down, right? Since they were able to turn you into the trust office of United States citizen, March 9th, 1933, page 83, second paragraph in the left-hand column says, the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It represents a mortgage on all the homes and other property of all the people in the nation. So we'll go take a look at this. Mortgage, right? Legal definition of mortgage says the party, here, let's take a look at this. The party who borrows the money and gives the mortgage, the debtor, right, is the mortgager. The party who pays the money or lends the money and receives the mortgage is the lender, the mortgagee. Under early English and U.S. law, the mortgage was treated as a complete transfer of title. Look at this. They mortgage your property rights. They mortgage your estates. It even admits it in Fiduciary Foundations of Administrative Law, that law review I bring up all the time, but I'm not going to bore you guys with it. It's a complete transfer of title from borrower to lender, right? The lender is entitled to not only payments of interest that's acquired through your income tax, right, on the debt, but also the rents and profits of the real estate. This meant as far as the borrower was concerned, the real estate was of no value, that is dead, until the debt was paid in full. Hence the Norman English name, mort, dead, gage, pledge. And that's really true. So now that you've been mortgaged and even you are held in trust as collateral for the public debt, you're considered civilly dead, civiliter mortis, or civilly dead. Another reason why you're in the ecclesiastical court where the satanic priest is wearing a black robe and he's governing the dead like Osiris, but I'm not going to get into all that on this one. With that being said, I'll give you an example of how this works. Say you wanted to give a mortgage. You wanted to borrow some money. So you put your farm up as the collateral, right? The farm, by operation of law, immediately gets placed in a trust. There's a trust created, okay? Now you have the obligation to work that farm because the lender is not going to come work the farm, and you still technically hold the farm and you still hold legal title to the farm. But it's encumbered because of the lien, And so now it's held in trust because the lender has an interest in it. So everything you produce on that farm goes to the guy who gave you the money until the loan is paid back. Now let's relate that to you having been mortgaged. Everything you think you own is held in trust. And the lenders, through their municipal corporations pretending to be courts, right, are allowed the rents and profits of it. So you have to pay for the use of it. So let's take it from the top. You purchase an automobile with Federal Reserve securities, which all carry the liens attached to that initial mortgage, right? The obligations attached to that initial mortgage of your property rights. So you can't actually even buy anything. So it's called purchasing because you purchase with negotiable instruments. And what you get is an encumbered piece of property now because of what you used to purchase it. And now you're required to go register it to the state. So when you register it, you're giving it to the state. The state gives you commercial advertising with their name on it to put on the back. Okay. And then police officer, then they charge you a fee for that, by the way. So that's part of the rents and profits. And then because it's now the state's property, you're required to be hired to drive it. So you have to go procure a license from the state. And driver is one employed to conduct a public coach, carriage, or other conveyance, right? Whether self-propelled or otherwise. It's an employment. And the state is employing you to drive the public property. That's what your driver's license is. Okay, now both of these account numbers, the license plate and the driver's license, are attached to your public trust, which is the Social Security number. Okay, and this allows the road pirate to come up behind you, create a state of peril for no reason, right? Because of your misuse of the property that's not yours. It's not yours. It's the state's property. You're just hired to use it. You have to use it the way that you're told by your employer to use it, which is set out in the Motor Vehicle Code. And so if you misuse it, the cop creates an attachment to your estate, to your trust, the public trust, through either the license plate or your driver's license number, creates an attachment to the public trust so that he can create his own debt obligations for the court. And now the court packages all these debt obligations called debt securities, such as traffic tickets, fines, court bonds, etc., packages them all together and sells them to institutional investors. Now, the skill of the inland pirate at enforcing compliance to, and the court, of course, to the new indenture that's made via the debt obligation. Say it's a traffic ticket. That's a new indenture, right? It's a constructive trust that now you have to satisfy the obligations by exchanging that, instrument for the equivalent amount of Federal Reserve negotiable instruments. Okay. Now, the better each municipality is at enforcing the compliance to whatever debt obligations they create, the higher their bond rating. The higher the bond rating, the more the higher the value they can sell these securities to institutional investors, because they know it's a good investment. They're like, hey, if we buy these court bonds and these traffic tickets and all this from this municipality with a AAA bond rating, we are guaranteed that they're going to force that public chattel to perform the obligations of these debt instruments. So we'll go ahead and invest, and we'll pay a little more because we know that you're going to make the chattel perform. That's how the system works, guys. That's how it works. So, and all of this is public commerce, right? So now with that clarified, and that's why you want to expatriate from the 14th Amendment, because then your property is no longer under administration, but you want to take it a step forward. You want to put it into a trust. So let me show you what I actually just finished and why I was a few minutes late to our stream today. Let me stop sharing this. Share screen. Boom. Let's see. Jesus, I'm going to assume. Mojica says, great live. Keep it here. Don't delete it. I need to come back and study more of this. Excellent. Absolutely, man. It's going to stay on Facebook and Rumble and YouTube. It's on all three. So this is what we're working on in the Juris, or what I have been working on for the Juris Society. So let me stop sharing this for a second. We're going to pull this up. And then we're going to share that. So this is the private trust. And this is going to be available for all the Juris Society members tonight, actually, because I just got to finish up the signature lines. But we have accomplished it, just like I told you I would before I go to Pennsylvania this coming weekend. But it tells you right here, this private trust is established under the common law right of contract. Oops, that's got to be capitalized. On the land in the Republic of Michigan by and between the undersigned trusters, settlers. There can be more than one truster or settler to a trust. And so if you're married and you have some things in your name, some things in her name, you just make you both the grantors and trusters. That way you can convey the property to the trust, and the trust can lawfully buy it from either one of you for gold and silver. So the all caps name is now going to be appointed trustee, whereas the common law name is the truster slash settler, right? And so declaration of authority, name and situs of trust. This is important, right? So it says the name of this private irrevocable trust is the House of Wells Private Trust. The situs of this trust is located without the territorial jurisdiction of the United States and within the Confederate state of Michigan in the geographical designation of the United States of America, right? So that's a big thing. Of America automatically puts it in the de jure states, and every state's Confederate, by the way. So because we have a Confederate Union, Penn Hollow v. Doan's Administrators, and I've shown this many times, but the revised statutes of Michigan 1846 says that Michigan is solicitous to give to her sister states and to the world her unequivocal desire to promote the peace and tranquility of the Confederacy, or the peace and harmony of the Confederacy. The Confederacy, that was 1846. That's well after the Constitution was ratified, because the Constitution is built on the Articles of Confederation. The Articles of Confederation are still valid, and where they're not contradictory to the Constitution. Okay. And also, we are a Confederate Union, because what a Confederate Union is, it says when a union is Confederate, not corporate, the sovereignty resides within the state. Penn Hollow v. Doan's Administrators. And the state the state reserves all rights which it did not expressly give to the union, and sovereignty can only be asserted but upon a clear title, meaning you cannot be encumbered and be sovereign. So what you're doing is you're creating this legal person that has no claims of encumbrance and exists without the 14th Amendment, right? Without the United States corporation and the corporate state. And so to further cement this, you have to put the mailing address for this trust, if receiving mail from within the territorial jurisdiction of the United States, which requires a zone improvement plan code, which is actually a zip code, which, in case that confuses anybody, we're just going to go ahead and put that in there, right? Zip code, all mail shall be addressed to as follows, right? So then you put that in there, boom. And you want to do care of non-post location. And then you want to do brackets for the zone improvement plan code number, okay? You want to do all brackets. So this is the entire trust agreement, right, of contract. But the most important aspects of this agreement, because this just lays out how the Board of Trustees will meet, what their powers are, et cetera, et cetera. But then there's a couple restrictions I put on the trust that are majorly important, okay? And that would be this one. The trustees may hire workmen for services deemed necessary for the proper operation of the trust. The trustees may compensate anyone, including themselves, in lawful money of the United States of America, as set forth in Article 1, Section 10 of the Constitution of the United States, for services rendered. All such compensation shall be fixed and paid at the Board of at the discretion. I'm glad I'm proofreading this, but at the discretion of the Board of Trustees, right? Trustee may waive compensation for services rendered. All lawful debts of this trust must be paid in lawful money, and the trust shall not discharge debts with debt securities of any kind, nor engage in the holding, exchanging, or disposing of debt securities of any kind. So no negotiable instruments is the trust allowed to deal in. Right? Nowhere, no, just absolutely restricted from that. Thank you, Pat. Glad you appreciate that. So, and then go down here, and there's another aspect of this. It says the trusts shall not be liable for the debts and obligations of the trusters, settlers, or the trustees, which may have been incurred in their personal, it's supposed to be personal, capacity outside of their performance of the duties set forth herein. So any encumbrances that they even try to presume, and this is why this will work even before you claim your estate, because you're creating a trust separate from the trust office of the 14th Amendment citizen and transferring the property into that trust. But I highly suggest you claim your estate. So like I said, that's what we do in the Juris Society, and we teach you how to stand on it. And then there's this one right here. The trust, let's see, hold on, no. Trust confers. Trust instruments, serve without bond. Yeah, I think it's down here. All right, so this trust is created by the common law of contracts in a private capacity and does not exist as a creature of the state, nor the United States, but as a natural person under the law of the land and shall act according to the common law. This trust retains all rights and sovereignty secured to the people of the United States as set forth in Chisholm v. Georgia, 2nd U.S. 219, including but not limited to the right to hold property in allodium. And then down here, it says, this trust is specifically prohibited from engaging in any form of public commerce, whether interstate, international, or otherwise. Now, the reason why this works, and we just looked at in the Weiss Concise Trustee Handbook, the Supreme Court's like Berry v. McCourt, that says that the contract the obligations of the private contract, common law contract that creates the trust are superior in obligation to the statutes and codes of the state. And if the statutes and codes of the state cause you to violate your contractual obligations to the trust, then they're null and void and they can't be enforced upon you. You cannot be caused per Article 1, Section 10 to violate the terms of any contracts under the common law of contracts. So because this is not allowed to engage in public commerce nor deal with negotiable instruments, that pretty much throws the motor vehicle code right out the window. And so once the trust takes possession of the automobile for lawful consideration, gold or silver, then when the road pirate comes up and tries to ask why you don't have commercial advertising on the back of your automobile and why you didn't convey the right of it to the state to be used as collateral for the public debt via registration, you can say, because I'm contractually obligated not to. Or even further, you can have the trustees sign an NDA, which I also have in the Juris Society folder, and say, I'm not allowed to disclose this trust or this automobile is registered to a private trust, and I'm under contractual obligation not to disclose the terms of that trust. Suffice to say, I cannot, this automobile cannot be entered into any public commercial, capacity whatsoever. Because to force you to now register it with these terms and to force you to obtain employment by the state via a driver's license to use it is in direct violation of these provisions that I put in this trust. Direct violation. No problem, Danny. So, hugely important. And one more for the people, just one more time, just for the people joining. And like I said, this will be available for the Juris Society this evening. So all you guys who are members of the Juris Society, my fellow jurists, can look forward to this. And yeah, it's just an 11-page document as opposed to the claim, which is a 31-page document. So when you rewrite it to personalize it for yourself, it won't be that bad. Not only that, but also there's an additional portion of this we're going to discuss in the Juris Society, which is the schedule. The schedule is the transferring of assets, either by, conveyance in one form or another, whether you want to issue ownership interest certificates to the grantors and settlers of the trust in exchange for the property, or you want to just do gold and silver, which is what I would suggest. That's how you're going to want to transfer the assets into the trust. So, all right, let's go ahead one more time for those of you that just joined. And this is why that trust works. Like he said up here, Berry v. McCourt. The court held that the express trust is a contractual relationship based on trust form. In Smith v. Morse, it was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is therefore violative of Article 1, Section 10 of the Constitution, because the express trust is created by the exercise of the natural right to contract, which cannot be abridged. The agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws passed by any of the several state legislatures or the codification of those statutes either, which is the Motor Vehicle Code, right? It's in Elliott v. Freeman, 1911. The court made it clear that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court that the trust relationship comes under the realm of equity based upon the common law right of contract and is not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. Because corporations and statutory trusts, any kind of registered trust, exists by the power of and at the mercy of whatever entity you applied to have that trust made, or whatever, you know what I mean? That's how that works. This private trust is a private natural person that exists entirely outside of any kind of contractual obligations with the state or the United States, which I like to sum up as the corporate state. So, David Koresh, the Juris Society is the membership. Basically, it's the members only portion of Burn the Corporate Fiction. Like I said, we're a tight-knit community. We've got some really, like, everybody in there is very, very solid, very knowledgeable. So if you're on some garbage, please do not join. Do not join. But if you're actually genuinely curious in accessing these templates and learning how to use them, as well as the other treaties of law, then feel free. But I reserve the right to boot anybody that causes us problems. If any of my well-established jurists have a problem with somebody, then that's just how it goes. You're gone. But we have not had any problems. We're about 47 strong. And like I said, we maintain constant communication. We meet 3 times a week, and we're a tight-knit community. So Jeff, if he's still in the chat, he's a member. And so is Say What and Roger Ledwell. And I think I've seen a couple, Ryan McVeigh, he's a longtime member of the Juris Society out of Pennsylvania. So anyways, that's why this works, and it works well. So again, and I'll recap the order of operations. All right. The establishment, the declaration, hold on, let me get out of this one. So the declaration, establishment, and publication of your house seal, which establishes your house on the record. Because again, like I said before, where it says in the original Illinois Constitution, the governor of this state shall make use of his private seal until a state seal shall be provided. At common law, anybody who has their stuff together has a house and seal. Anyone who is going to be eligible to be governor of the state of Illinois was presumed to have a private seal already. This is biblical even. It protects you against fraud and against someone entering you into a contract against your will. It also acts as its own proof, its own consideration when you seal a contract. Okay, because you're a foreign state to the United States. So when you seal something that you're sending to the United States corporation, right, or within the territorial jurisdiction of the United States, you seal it and you're putting the honor of your house as consideration on what you're sending. And that serves as it says the seal of a foreign state proves itself. That's in Bouvier's Law Dictionary under the definition of seal. All right, so you establish your house seal, which establishes your house on the public record. Then you claim your estate, right? Then you establish your private trust, which I just showed you. I have to just put the last signature lines on there, and then it will go into the Juris Society folder. There's also, what was I going to say? We're going to go back here. A plethora of treaties and other awesome documents. I actually just put these 2 in here for those of you that are in the Juris Society. And you may not know because I just did this morning, but it's under land patents. I created a folder with this awesome book by Ron Gibson. It's called Land Patents. and he's got all verifiable knowledge. He explains a path to get the allodial title to your home. Maybe we'll go through this in short order after we get through the trust stuff and the secret maritime jurisdiction and the Juris Society. I would like to read this book because I know many of you are curious on how to, but essentially what it does, what he says is that exactly what I tell you guys all the time. You pull an abstract on the land, okay, and you go back to when the land was entered into a registry system that is not supposed to be here, or taken under administration by the county and entered into zoning programs via the zip codes, right? The zone improvement plan. That's with zoning, residential zoning, all that crap. If you guys watch my short, either way, they're not supposed to do that if there's a living man or woman able to take possession of the land. So, and then you acknowledge the original land patent on the record and send it to all interested parties. He lays out in much greater detail what I'm talking about and why it works. And that might sound beyond belief for many of you, but I'll tell you what, they're so worried about it that it's becoming increasingly difficult to obtain an abstract on any piece of land. You can just ask Ryan McVeigh if he's still in the chat. He went to have one done a while back, and there was only 3 in the entire state of Pennsylvania that did it. And the attorneys have been hard at work destroying original records, original deeds and conveyances that trace back to the land patent. Because once you can own land, once you have absolute ownership of your land, which is our birthright here in the United States, then you're literally the king of your land, and there's nothing anybody can do. You own the air above it and the soil below it, the soil and minerals below it. You have all mineral rights. You have all air rights, everything. That means the freaking airline companies would have to pay you to use your airspace type of stuff. That's really what allodial means. It's how powerful it is. And that's why if you type allodial into your phone or computer right now, it'll probably tell you you're misspelling a word, because they're trying to remove it from the public lexicon, right? They're trying to remove it from the public zeitgeist because they want you to have no idea, no concept of absolute ownership. They want you to believe that there's always somebody above you that you have to pay, when that is not the case, as proven in the Wisconsin state constitution, which I showed you guys right here. All lands within the state are declared to be allodial and feudal tenures are prohibited. That means all lands everywhere are allodial because of Article 4, Section 2 of the Constitution, that is called the equal footing doctrine. It declares that all states enter into the union on equal footing with the original 13 states. This state didn't enter the union until 1848. So 1847/1848. So that tells you that because they were only able to do this because that was the case everywhere else. And we can also see this in the land pat, or the General Land Office report, where they tell you that the individual title derived from the government involves the entire transfer of the ownership of the soil. It is purely allodial, with all incidents pertaining to the title, to that title, as substantial as in the infancy of the Teutonic civilization, which is where the concept of allodium came from, the Vikings. But following in the wake of this fundamental reform in our state land laws are several others which constitute approximate corollaries. And you guys can read this at your leisure if you want. This is page 29. But allodium, like I said, represents an oath. It comes from the Old Norse othala, which means ancestral inheritance, and it's also the origin of the word oath. And it essentially means all oath, because it is an oath between you and God, an oath by you to God to be a good steward of the land and caretaker of the land in exchange for having absolute dominion over the land. Absolute owned. Let's see. Onshore, I think that's how you say your name, says the fact that people believe they are owed and owned a piece of the land. Well, you apparently didn't hear what I said. So yeah, and ownership rights. But what allodial actually means, it comes from the biblical concept in Leviticus. It says the land shall not be sold forever. Let's see if I can pull that up. The land shall not be sold forever. Dude, I think it's 25 something. Shall not be sold forever. Leviticus. So 25:23. Yep. So you go here and it says Oh, well, I hate new translations, so we're going to go to an older translation for sure. We'll just click this. It says, the land shall not be sold forever, for the land is mine, and ye are strangers and sojourners with me. Okay, because it's God's land. So more so what allodium means, for those of you that are sticklers on that particular point, as far as everyone else is concerned, other than God, you have absolute ownership. But in truth, allodium is essentially an oath by you to God to be a good steward and caretaker of the land he has given you dominion over. So you only have dominion over it. Obviously, nobody can own above God. But as far as all other men and women are concerned, you absolutely own it. And the only person that has a superior claim is God. So it's a moot point to have to include that every time. You can just say allodium is absolute ownership. You can just say that, because obviously the latter, the former part, or what I just said is taken for granted. It's like, yeah, duh. Obviously everything belongs to God. But so yeah, you place all your stuff in a private express trust. And that's that. So I would take some questions before I shut this down, if anybody has any in the chat. Let me go back up and see what we got here. Poncher says, sounds Zionist, huh? All right. Well, a jurist is a student of the law, as opposed to an attorney, which is a feudal term, actually. So we go to a torn, right? That's why we're called jurists, not lawyers or attorney. But lawyer could also be accurate. I just think jurist sounds better. To attorn in feudal law is to, here, let me pull this up for you. To attorn in feudal law is to turn or transfer homage and service from one lord to another. This is the act of feudatories, vassals, or tenants upon the alienation of the estate. So you're considered essentially a vassal and a tenant of the corporate state, and the attorney is transferring your homage and service to the court so that they can create their own little constructive trust and trust indenture, correlating trust indenture, and get you to perform the obligations of that indenture, whether it be pay a fine or do probation or whatever. The bonding aspect of this is actually interesting too. So innocent until proven guilty. You have if you are one of the people of the states, you have the Sixth Amendment protection against the powers of the federal government, which is the right to a trial by jury and a right to know the nature and cause of your accusations and to face your accuser. It's the Sixth Amendment right. So how do they do pretrial probation for, like, say you get a DUI, which again, DUIs can only exist in equity because equity is the jurisdiction of fantasy, which is why it's distinguished from law. It's not law, right? So that's why it says in Article 3, Section 2, it says the judicial power shall extend to all cases in law and equity, making a distinction between the two because there is only one law, and then everything else is pretty much varying forms of equity, whether it be admiralty and maritime or military or probate, ecclesiastical jurisdiction, right? Or just equity itself. They're all just essentially different types of equity dealing with a legal fiction, a trust office, pretty much, right? And you can break it down that simply, that law and equity are really the only two jurisdictions. One is law, the other is not. And as Blackstone said, that I read earlier, that law without equity, though hard and disagreeable, is much more preferable than equity without law, which is what we have now, which would make every judge a legislator, right? And Bouvier says that the discretion of a judge is the law of tyrants. That's why they like equity, okay? The equity deals with fictions, right? And you can only have an injunction in equity, meaning stop somebody from doing something in the future. You can only do that in equity. And you can only have a DUI in equity. Not that I agree with, so I do not support drunk driving, but in a sovereign society, like if we were at what we were at the original republic, it would be presumed that you were responsible enough and wise enough to not drive a several thousand-pound vehicle while under the influence of narcotics or alcohol. It would be presumed that you would just be, because that's why you're trusted to be sovereign. I mean, what was it? I think it was John Adams said, let me look this up. Whoops. John Adams says that our government is suited for a religious and moral people. Just so you guys know, this is actually a quote. And moral people. Right? And I think it was John Adams. Yeah, so right here. John Adams said, our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. This because we are actually free as people of the states. We are sovereign. The government cannot dictate what you do with your property. They can't tax your labor. None of that. They can't tell you, oh, you have to come get a permit to build an addition or a fence or something stupid like that. No, it's your property. Do whatever the hell you want on it, so long as you don't hurt anybody. And that's what allodial title actually means. So, like I said, DUIs can only exist in equity. Unfortunately, we're in a position where they justifiably enforce that because people are so stupid they drive around drunk, and they're no longer a moral and religious people like we were at the beginning of this republic. And with that being said, pretrial probation. So say you get a DUI, which can only exist in equity. And then how do they put you on pretrial probation if you're guilty or if you're innocent until proven guilty? It's the bond. That's the trust indenture. So they make it part of your bond conditions that you have to do pretrial probation. It's the only way they can do it. And then they get to sell that bond to institutional investors. And based on their bond rating, if it's a AAA bond rating, then they'll go to the other side of the country to pick you up for a violation of those trust indentures. Right? They get scored on how well they enforce the compliance to the debt obligations they create. And that's the bond rating. And so they get to create a bond and say part of the bond, which is a trust indenture, it's a constructive trust and a trust indenture, and say that you have to drug test 3 times a week, and you have to breathalyze 3 times a week, and you have to attend counseling, all before you've even been found guilty. You have to attend drug counseling and all that because they make it stipulations of the bond. And then that bond has a monetary value, right? Not to mention the other negotiable instruments that are created by contracting with the drug testing and alcohol testing places, the counseling offices, because they refer you only to these specific places that they have contracts with. And these places score government contracts. It's just one big prison industrial complex, man. It's insane. It's insane. The food companies that are involved with the prison system and jail systems, right? Well, they call it corrections because, again, like I tell you guys all the time, it always has to be presented as if it's for your benefit so they can appropriate money against your estate for it. It always has to be for the benefit of the estate under administration. So they consider going to jail corrections, and that's a benefit. You know, so when you go into the courtroom and you say you're smart enough and you've learned that it's all the jurisdiction of equity now, that they've basically buried law by locking you into a trust indenture, but you go into the courtroom and you say, I'm the beneficiary. They go, okay, here's your benefit. Go to jail. Because beneficiary is a position with no power. You are entitled to nothing but the benefit, and you have no controlling interest in what they consider benefits are not something you want. Okay. So I've seen people put it to where, okay, well, I'm the beneficiary and I've taken control of the estate. That is literally a contradictory statement. As a contradiction in terms. If you are the beneficiary, you have not taken control of the estate. You have agreed to allow the estate to be under administration in exchange for a benefit. That's what the entire 14th Amendment is taking estates under administration in exchange for privileges, immunities, and benefits and protection against everything except the one thing you actually need protection against, which is the government, right? So the heir takes control of the estate. That's what you are. If you want to go in and say, I'm the heir and executor, if you want to appoint yourself executor, right? So I'm the heir and executor of the res defendant estate because this estate is not under administration. I have reclaimed it, right? So without further ado, I'm going to go out on, let's see if we have any questions real quick. Sergeant Frog Dog says, I've been linking together the MVA has a contractual agreement with the BMV, DMV Bureau of Motor Vehicles, Department of Motor Vehicles, and this place is contracted with all 50 states and multiple countries. Yeah, it's part of it. Just like child support and everything else, all this commercial stuff is part of international treaties as well. That's how they can write enactments in like India or New Zealand or something and then apply it here because it's all an international system. The one world government is all but set up. Just like Jerry Sonamick says, he says, they plan and have been moving property and assets, resources belonging to the people into a trust, whether it be Noahide or World Trust. They plan to lock it all away and lock you into equity and then put AI governance in charge of that equity to eliminate due process because, well, the AI cannot be wrong. It's seen you speed, it's seen you jaywalk, so it's automatically just going to deduct stuff out of your account. And you do not even have the ability to challenge jurisdiction, which is why they want to set up AI governance, which is why everyone needs to claim their estates as quickly as possible. So, yeah, let me go ahead and stop sharing this for a second. And there was a video I want to show you guys before I shut this down today. And this is thanks to Mojo Shop, a.k.a. Randy, one of the members of the Jurist Society. He sent this to me, I think it was either yesterday or the day before. Either way, it's a success. It's a really good video. You guys will appreciate it. So let me pull this up real quick. Don't do it to me. It's going to make it. There we go. All right. Let's click that. And then pause it. All right. Share this with you guys. You guys will like this video. All right. Here's another unlawful stop. See what they want now.
Hello, I'm Officer Stanfield, Rexburg Police Department. Reason for the stop is your fictitious plate.
That's not fictitious. It's actually been deregistered. Okay. It's private. There's all the...
I just need your registration and license. I need her license.
That's it.
I'm not talking to you. I need her license, the registration, and the insurance for the vehicle.
Still trying to hand it to you.
This is the registration?
Yep, and the insurance.
Okay.
Where the hell is the passport?
I need a driver's license.
She doesn't have a driver's license. She's traveling. This is a private conveyance.
I don't do this.
Don't do what?
I don't do the whole sovereign citizen thing.
It's not a sovereign citizen thing. It's a private conveyance. That's why there's no Idaho plate.
Stop. In Idaho, you need to have a...
That right there is why I hate the term sovereign citizen. I'm not going to keep stopping this, but that right, because it's a trigger for the cops. Just like that, well, I'm not doing the sovereign citizen. Dude, you're so ignorant. You have no idea what the law is you're supposed to be enforcing, right? You're a policy enforcement officer. You don't realize who it applies to and who it does not apply to. It applies to only those who avail themselves of benefits of the corporate state, all right? Not people operating in their private capacity or acting in their private capacity, traveling in their private capacity. And that's the whole point of the private express trust. I just want to point this out is you're removing the conveyance from being held by a public trust office, which is the 14th Amendment citizen, being hired by the state to use public property, into a private trust, which is outside of that commercial arrangement, specifically prohibited from engaging in it. So let's finish.
The license to drive on the public roads.
I'm not in the state of Idaho. I'm in the territory of Idaho. Can you please write your ticket? We'll be happy to accept any ticket you want.
Okay. That's 24. Can I get another?
You're not in any danger here.
I know.
I deal with these all the time.
And you should just register your vehicle and get a license.
Right. I should actually give my property away to the state, right? That's what happens. You don't understand that. You're giving your property to the state. That's why you have to pay them a fee every year.
Yeah, I mean...
This is mine. I own it.
Okay.
I don't pay anybody to travel on the roadways. My tax is already paid for. Supreme Court's already ruled on that, but they don't teach you guys that because they want you out here trying to take money from people and write citations. Do you know where those go, your citations?
To the office at Rexburg Police Department.
Yeah, it's not what happens with them. What they do is they unlawfully put those debts against people.
Okay.
And then they throw
Yep.
people in jail for admiralty crimes when there is no common law violation. You have to have a victim to have a crime under the common law. They don't teach you that. They want you guys out here victimizing your fellow Americans, pretending like we're criminals because we're traveling out here without some corporate state's license plate on our own personal conveyances.
So why do you have it insured?
That's exactly right.
Because I don't want to have anybody else lose their property if somebody that's operating my conveyance accidentally runs into them. I'm a law-abiding man. I'm not going to.
So I got to pause it there. When it comes to insurance, assurance is generally always is under some form of maritime jurisdiction. Insurance companies actually precede the banks. Before there were banks, there were insurance companies issuing bottomry bonds on the cargo hulls of ships, right? With that being said, and you logically have to think about it, when you get something insured, you are giving the insurer an interest in the property and the way the property is used, because now, depending on how that property is used, the insurer could experience a loss in having to cover the value of that property. So by operation of law and obviously equity, they are able to have an interest in a regulatory interest in the property once you insure it. Now, that being said, when you remove it into the private and you claim your estate, that's when you negotiate a private, this unique contract with the insurance company that doesn't blanket put you under all the jurisdictional authorities of the corporate state. So you have to actually negotiate what the regulations are going to be determining your use, because they do lawfully have a right to regulate the use of the property if they're agreeing to insure the value of it. And that's just how that works. So if you choose to get insurance, which I'm not saying that it's prudent when you're because when you remove yourself from the commercial system or the corporate system, right, the corporate state, you then assume full commercial liability, right, which is important to realize, which is what you want, because that means you're not part of the corporate state. So it does at the same time make sense to have some sort of insurance on your public conveyance. However, realize that it will also give the insurer a regulatory interest in the property. So you have to negotiate a special contract outside of the normal avenues of acquiring insurance. You'll have to find an insurer that's willing to negotiate a special contract with you, et cetera, if you so choose. Like he said, he doesn't want anybody else to experience loss or injury because he's a law-abiding man. I can relate to that. It's exactly right. However, do you want to give an insurance company interest in your property? I'm just saying. And that's a decision for you to make, right? I have my own opinions on the prudence of it, but anyways, let's go.
You're not going to rob anybody of something.
And I appreciate your effort. I appreciate you getting your insurance for that.
Mm-hmm. I'm not required to have insurance either, by the way, but I do carry it because I'm responsible.
Thank you.
David Koresh says, can't you bond your own vehicle? You have to do that anyway. You'll hear him mention it here in a second.
So the Hartford is the deregistration? Is that
The Hartford's the insurance.
okay? So
And this is the bond for the vehicle. The law says it has to be bonded. So that's the bond, the ACORD certificate.
175, even 22. Thanks. Okay.
If you'd like to write me a ticket, please do so. Just make it out to that address. I'll accept it.
You would probably think I'm not on your side on this. I'm probably one of the more libertarian officers. Okay, I believe in the Constitution.
Mm-hmm.
I believe the government should not have any corporate hold on people.
Yeah,
I agree with that. But per Idaho statute, to travel on the public roadway, you need to have registration and a license.
Okay, so let me explain something if you don't mind. Okay.
Now, what I would have said there is, no, that's wrong. Per Idaho statute, you have to have a license to drive or operate, both of which are commercial terms, are terms that indicate employment. In order for you to drive a public conveyance, right, to conduct a public conveyance, you have to be employed by the state. You have to have a license, right? And they consider that employment a privilege. So it's the word jurisdiction, juris meaning law, diction, like dictionary, meaning words. The words you use determine the law that you're under, right? Or what jurisdiction you're under. And so when he said travel, I would have hit him on that right there. That's wrong. You do not have to have a license to travel. You have to have a license to drive. And this is a fact. You guys do your own deep dive into the words through the old dictionaries. But I know for a fact, every single time I've looked up that word in multiple dictionaries, from the different versions of Black's Law to Bouvier's to, I have some really old ones from the 1700s, operate and drive both signify employment. And drive outright says employment. So to drive or operate is to be employed. And in order to be employed, you have to have a license. And that's what the driver's license is basically an employment contract by the state to use their public property. So,
do you have a passport? In fact, open that passport up if you'd like to the back, or wherever it says citizen/national. It's on there. I can find it for you if you'd like. But this tells you right here that there's two statuses. You're a U.S. citizen, a 14th Amendment U.S. citizen. You have a driver's license. You're required to have one because you work for the government.
Yes.
Unless I'm hauling people or products, I'm not engaged in commerce. Only people engaged in commerce on these highways have to have driver's licenses. That's who the
right.
code applies to. It does not apply to regular Americans. Unless I have an autograph with something on it like a driver's license, which I don't have. I'm not required to have one. Now, every time you write a ticket, and you can look this up if you want to.
And even still, the license is for using public conveyances, which is what the vehicle or the automobile becomes, a motor vehicle, when you register it. Because you're giving it to the state puts their name on it. It's now the state's property. You are the mere usufruct, which means you only have the right of use. Usufructuary is usury of property, right? It's charging interest on the use of property, is a simple way to put it, right? So when you register the automobile, it becomes exactly that, public property. And so then the state must employ you, right? Requires that you be employed to use their property. You be employed by the state. One good question to ask the judge is, if I'm employed by the state, then why does the state not compensate me? Is the workman not worthy of his hire? Right? Because it's common law stuff right there. So
let's see if I'm full of shit. You can look it up and you'll find none of those tickets ever go to court. Why? Because the attorneys know I know what the fuck they're doing. These guys are sending you out here to risk your life so that they can have a steady stream of victims in these bullshit courts. How do you feel about that?
I don't like it.
I would piss me off too. I have a bachelor's in criminal justice. I didn't go to school for that bullshit so that some fucking dirtbag attorney can take my mom, me, or anybody else and drag them through their courts for revenue. That's bullshit.
Okay.
Once guys like you start standing up and telling them, hey, you know what? Go fuck yourself. I'm here to protect and serve. I'm not here to do that.
Even my chief, you could ask my chief. I rarely write tickets.
I love you, bro. I'm not kidding you. I do. If that's the way you feel, let me shake your hand. I'm not kidding you.
I'm not somebody who goes out and collects revenue for the state. That's not what I do. If somebody's putting somebody in danger, I'm more inclined to write a ticket. You know what I mean?
Of course. That's what I would do too. You're protecting and serving. You know your job.
But even still, that's equity because it's pre-crime. Pre-crime, the very concept of pre-crime is punishing somebody for what they might have done, which can only happen in equity because it's fictional. It's fantasy land. You're not psychic. You don't know what was going to happen. There's not some precog sitting in a pool and Tom Cruise coming in to save the day or none of that shit, right? So that's another reason why the jurisdiction of equity is bullshit. At least man's equity, not God's equity, obviously. It's man's equity is the counterfeit version of God's equity.
To educate.
And that's what I do.
So,
and I take veterans out all the time. That's what I do. I actually have a ministry that serves veterans, first responders, and law enforcement who are injured in the line of duty. I take them out in the woods. I help them with PTSD. I help them recover. I help them get better. That's what I'm about. And I'm also about educating all of you guys, because you guys kill, not you, officers kill 1,200 people a year, and over 200 or something like that every 3 years die. And when people wake up and realize, it's literally the Satanists, just like it says in Revelation. The souls of men are bought and sold. How is that? It's through anything with your autograph. It's commercial. That's how they're doing it.
Okay. So what her name is?
Donetta.
Donetta, is she?
That's my mother.
Your mother. Okay.
Yep.
So what I'll do, I'll write a written warning.
Mm-hmm.
Okay, for just the registration. Okay. I'm gonna implore you to get the vehicle registered. Okay.
I actually
see that's what he has to do, and it's tough for a cop like this in his position because he actually agrees with. He sees the reason. He's actually learning, right, which is rare for a policy enforcement mall cop type of individual, but he'll be ridiculed by his colleagues. They literally foster a deputy of 13 years commented on one of the shorts I made recently. He said, hey, I was a deputy for 13 years. He says, not all cops are bad. He said, but I had to leave due to the corruption. And once I realized what the system was, and I was like, I totally get that. With that being said, it's many of the cops do have that egotistical blind obedience to authority and don't question me, not a public servant, but a public tyrant. And these police departments literally enculture and foster that type of attitude into the police officer. So they do this. So this guy, and I see many of you in the comments, like Corbett and Griffin, you guys are like, yeah, this cop's going to get in some trouble for this. Probably. And that's unfortunate because he's actually been very reasonable. And if cops actually just worried about crime, which is, harm, injury, or loss caused by one to another, as opposed to inland piracy and pillaging the estates of the people, then, officer safety wouldn't be such a huge concern because people wouldn't have so much animosity towards them. And not only that, but they might actually be celebrated members of society for putting their lives on the line to actually help people and stop crime, not pillage the estates of people by creating attachments to their public trust and all that, right? So he's going to write a written warning. He let the dude go, so on and so forth. Dude stood his ground. He explained himself exactly. Everything he said was on point, right? And he even said, okay, well, I'm not here to convince you. Go ahead and write whatever attachment you're going to try to make, and I'll just deal with it in the courtroom, right? So that's how your interactions with these policy enforcement mall cops people should be. If a lot of these guys don't know this stuff, and then even when they are reasonable and they're willing to learn it, they're ridiculed by their colleagues for it. So, and the deputy who had commented on my video talking about, how he realized he said it was actually an inmate in the jail he worked at that had shown him exactly how corrupt and stuff. So these guys do listen, and they always try with them and always, be civil with them, and said they're just working a job, generally a job they took because they're, not capable of making a good living doing anything else. In my opinion, it seems to be the case with a lot of them, or they're just power tripping, egotistical, megalomaniacal assholes. But there are good ones out there. That's true. So, so Monty says, eventually this cop will resign because he's obviously waking up. Exactly. Yeah, that's what I'm saying too. All right, with that, here, I'll link this reel if you guys want to have it, watch it, take notes, because that was an excellent interaction with a policy enforcer. And now I'm going to address this one last, finds drugs in his locker at the station. That's what Griffin said. Yeah, all of a sudden he's going to have drugs in his locker. No shit. Unfortunately, it's probably true. Something along those lines. So, all right. So there was a question Toshiro had asked here. He says, let me go back up and, all right. So he says, what if you cannot afford to purchase a home with cash? Is it better to rent or purchase with a mortgage? Okay. So first, like I said, anytime you purchase with negotiable instruments, these negotiable instruments represent the mortgage of your estate and your property rights. So you'll forever be a tenant on the land unless you do as I was talking about before, even after you've paid off the mortgage. Now, with that being said, if you are just in that position where you're not able to do anything else right now, but you need to secure a place to live, renting is essentially, it's a give or take. It depends on, so renting is essentially like throwing away money. You're not actually building equity in anything, right? But also all of the incidents like, so the liability is on the landlord to maintain the home, fix problems with the home, et cetera, which can be pretty expensive. So that liability is all on the landlord. But all the money you give him is basically just going to nothing, just existing, right? Whereas if you buy a home, well, not buy, purchase, quote unquote, a home, right? Or with a mortgage, what you're doing is you're putting the land up as collateral for the access to your own credit. I've explained that before. I'm not, it's stupid. It's a stupid system, but still the way they have it set up is if you do go that route with the mortgage, then all of the money you pay into the mortgage is actually building equity in the property, your equitable interest in the property, so that when you turn around and sell it later, even if you haven't finished paying it off, you get everything above what's still owed on the mortgage. So you're not throwing away the money you're paying. It's basically like sticking it in savings, if you will, or tying it up in an asset. The only thing that sucks about that is that that's also subject to the housing market and the fluctuations therein. You may have bought it high and then the housing market crashes, as it's probably going to do anytime now. And then all of a sudden, you know, you're still on the hook for, say, like $150,000 and the property is only worth 80 now. So you couldn't even sell it to recoup your investment in the first place. So it's just really, it just depends on what kind of liability you're comfortable with, I guess. And if you're not comfortable with any liability, then renting is probably the way to go, because while you're throwing the money away, essentially, you also are shielding yourself from liability associated with the property. And you could also look at it like this: even after you pay off the mortgage, you're still renting it. So from the corporate state until you trace that allodial title, that land patent. So with that, I appreciate you guys very much. Always fun being able to discuss law with you all, and I hope you got something out of this. I will, for those of you who might be interested in the Jurist Society, like I said, please, no trolls and people on garbage need not apply. But if you're genuinely interested, I will post a link in the description of this stream after I shut it down. And also you can join on Facebook as well. I have just opened up membership opportunity on that side as well. So if you prefer the platform of Facebook, that's what you enjoy interacting with, then you can also become a Jurist Society member there, and you will have access to all of our members only meetings. So with that being said, I appreciate you guys. Thank you for being here today. Hopefully you got some good information out of this, and I will see you next time. Have a good day, everyone.